May it please the court. My name is Seth Gagliardi, and with my co-counsel Patrick McKee, I represent the state of Texas appellee in this case. During my time before the court, I'll address the Confrontation Clause issue. During Mr. McKee's time before the court, he will address the ineffective assistance of counsel issue. The standard of review in this case is de novo under this court's holding in Charles v. State in 2004. The appellee respectfully requests this court affirm the 15th District Court of Appeals ruling and find there was no Confrontation Clause violation for 3 reasons. First, the lab report is not testimonial. Second, even if the report is testimonial, the testimony of Mr. Harbor and the raw data were still properly admissible. And third, if there was error, it was harmless error. As to my first point, the lab report is not testimonial in nature. Crawford determined that testimony, while not specifically defining testimonial in the decision, stated that there are 3 kinds of principal concerns under the Confrontation Clause. First is ex parte statements of a formal nature, affidavits or custodial examinations. Second, extrajudicial statements in formalized manner, again, affidavits, depositions, or confessions. And third, statements made under circumstances which would lead an objective party to determine that they would be used at trial. Now, the lab report is not testimonial in any of these 3 ways.
Have you read Michigan v. Bryant, the Supreme Court's most recent decision on Confrontation Clause?
No, Your Honor. The record does not contain Michigan v. Bryant.
It was issued this Monday. But they focus on the primary purpose test of Davis in seeming to define what testimonial statements are. What was the purpose of this lab report, if not to establish that there's scientific evidence that Ms. Herbster was intoxicated?
Your Honor, while it's true that the purpose of this lab report may have been to make an assertion, the person making that assertion is the gas chromatograph machine. And although that may be an assertion, United States v. Washington in 2007 found that assertions by machines are not technically declarations and therefore not testimonial in nature. And what's particularly important about United States v. Washington is that although it was a 2007 decision by the 4th Circuit, that decision was denied certiorari by the Supreme Court only 4 days after the ruling in Melendez-Diaz in 2009. So this topic was fresh on the Supreme Court's mind when United States v. Washington was issued. And the difference between Melendez-Diaz, the distinction between Melendez-Diaz and Washington, is that in Melendez-Diaz, the certificates were signed, they were notarized, but most importantly, they were presented without the benefit of an expert there to in any way testify to what sort of analysis or procedure was done to come to this conclusion. Although in Melendez-Diaz, the Supreme...
But we didn't have the person who ran the test testify in this case either.
And Your Honor,
we had no one who had personal knowledge of how the tests were run testify, did we?
Respectfully, Your Honor, we did, although that knowledge is through the hearsay that you brought up earlier, and there was not a hearsay.
He didn't observe it, he didn't touch it, he didn't feel it, he didn't taste it, he didn't smell it. He wasn't a recipient witness of the testing, was he?
Correct, Your Honor. On page 30 of the record, Mr. Harbor admits that he had no personal knowledge of how the test was run. What's also important about that in terms of both United States v. Washington and United States v. Darden out of the District of Maryland in 2009 is that neither of the experts in that case witnessed the test. They only looked at the results. None of the experts in Washington or Darden that testified in those cases were the analysts that specifically operated the gas chromatograph machine. Exactly the case in our case here.
No, but the witness who testified here, it's Harbor, correct?
Yes, Your Honor, it's Mr. Harbor.
Mr. Harbor was relying on a report generated by the other analysts, right?
Yes, Your Honor, that's correct.
Well, why isn't that report by the other analyst a testimonial statement by the other analyst?
Your Honor, that report is not a testimonial statement because it's merely a scrivener's transcribing, as is shown on the record on page 2. All Miss Lindsay does is look at the printout from the gas chromatograph machine, and she transcribes that number, the 0.18 milliliters per, or grams per 100 milliliters blood alcohol content, onto her report. And that situation was addressed in a recent case out of the Supreme Court in New Mexico, which was State versus Bullcoming, in which they found that while, and we disagree with this, the analyst report is testimonial, there's no confrontation clause issue because there's the opportunity to cross-examine an expert that is familiar with the procedures, and all the analyst does is serve as a scrivener to transcribe those numbers from the gas chromatograph to the report.
Now, didn't the Supreme Court actually grant cert in that case?
Your Honor, while the Supreme Court may have granted cert in that case, that is something that we're constructively advised to disregard.
Now, going back to your issue with Washington, you said that cert was denied and that should impact our decision here. What percentage of cases are granted cert for the Supreme Court?
Your Honor, I could file a supplemental brief on that, but I have to admit I am not familiar.
They get like 8 or 9,000 petitions filed every year, and they grant maybe 100. Can
Yes,
we
Your Honor.
really take any kind of guidance by the fact that they denied cert in a case?
Your Honor, I think it's, yes, I think in this case you can take some guidance because of the proximity. The 4 days between Melendez-Diaz and Washington, this issue was on the court's mind when they denied cert in that case.
Do you know how many other cases they denied cert that day?
No, Your Honor, I don't have the numbers on how many cases they denied cert.
Well, then that, you know, if they denied like 150 cases that day, doesn't that raise a question whether or not this was really the court's focus at that time?
Your Honor, while it may not be, of course, the court's only focus, I believe it's objective to consider that the two may have been discussed in the same realm, considering that the analysis both concerned experts, scientific results, and the difference between those scientific results. It's critical to note that in Melendez-Diaz, again, there was no expert to testify, but what they did conclude later on was that there was some sort of independent judgment required in the drug analysis of Melendez-Diaz, while there's no independent judgment required in the gas chromatograph operation. So that is yet another distinction between those two cases.
Well, going back to my speeding example